Thank you. Thank you everyone for coming as well. It's nice to see such great attendance for the commercial bar. I really wanted to be a barrister basically for two reasons, and they are sort of the same reasons that I think most people want to be barristers. The first is that I was interested in the intellectual challenge. I did some work experience at solicitors' firms, and quite often I found the really difficult problems. Once it got, really difficult, then they would instruct a barrister to give you the final answer of what the law says. And I wanted to do that part rather than the part before that. And then the second reason was that I quite enjoyed sort of taking the lead, the tactical lead in teams and things like that. And I think, I was just interested in taking that role rather than being, number 5 in the team and not being able to make any decisions yourself. So I think that's really why I chose the bar. In terms of why the commercial bar, I think because of, to be honest, quite often the amount of money involved in some of these cases, they give you the time, as in you are given the time by clients to really look hard at these problems and find the answer after weeks and weeks of research or whatever it is. And so you get really complex, difficult problems. And unfortunately, it's because of the amount of money involved in these cases sometimes, but you are fighting against people that are really clever and you're trying to find difficult answers to difficult questions. And I think that's what attracted me about the commercial bar.
I echo pretty much everything that Ben has just said. For the reasons why I wanted to be a barrister, I graduated with a law degree, not really knowing exactly what it was I wanted to do, although actually I was really interested in public law. But I did a lot of work in different law firms, and I eventually qualified as a solicitor before I moved over. And what I had found, similarly to Ben, is that the bits that I really enjoyed were when I got to do bits of advocacy, which wasn't very often, but I did get to do it, doing the legal research and really getting to grips with the detail of a legal problem and thinking about the law, and doing strategic advice and drafting legal documents. And you get to do some of those things as a solicitor, but as Ben said, very often when they get really difficult and intricate and at their most interesting, I then had to hand that over to somebody else. And I got very cross about that. And I thought, well, why don't I go and do that job instead? So I applied for Pupillage, and my chambers was very kind enough to take me on. Why commercial law? I am at the commercial chancery bar, so I deal with similar sorts of work that Ben would do, but I also deal with a range of work in what you might call the private client sphere, and the sort of unifying theme is things to do with property and equity and the ways in which money and assets and business assets are held and transacted, and people interact with them in legal ways. And what you've got there is a lot of legal constructs and abstract ideas like what is a company, what is a trust, and how do those things hold and deal with property and do deals between each other. And finding ways to solve those very practical problems that people have in their lives or in their businesses by applying your legal analysis was what I found really, really interesting and attractive. As Ben says, you're not in court every day. You're often given a lot of time to work up to any given court appearance, so you've really got the time to think through the intricacies of the problem. Sometimes you are deep in a textbook and you stumble on what you think is a really clever answer. That's great. And then you find out how you can really precisely fit that onto the problem that you've got in front of you, and you think, yes, this is the killer argument. And having the time to really put that together and use your brain to work your way through something is really great. As Ben also said, the cases are often, not always, but often quite high value, which means you'll be given a lot of time to work on it. It also means, not wishing to be vulgar, but the work is pretty well remunerated compared to other areas at the bar. That's important to some people, it's not important to others, but I think it is fair and reasonable to point it out. So yeah, if you're interested in the black letter law and how that applies to real people's problems in their lives and businesses, then I really urge you to have a think about the commercial bar. Yeah.
Yes. You both mentioned that unlike solicitors, you get to make tactical decisions or strategic decisions, as you mentioned. That confuses a little bit with the fact that the solicitor instructs you. So how does it all work together? So you've got your instructions, but actually how the case progresses. Do you give instructions to solicitor to find out?
It's a good question, I think. I mean, what you're doing is you're not so much running the case day to day. The solicitor does that. The extent to which you are involved in a given case will vary. Sometimes you will be very hands-off and the solicitor will come to you saying, there is now a court hearing, here is all the papers we've put together for the case, you've never seen the case before, you get ready and you do it. You might make some strategic or tactical calls about how you do that bit, and you might perhaps have input in settlement discussions, but ultimately you've not run it. Or you might be involved right the way through. But in either case, you are providing your advice. You're an external professional consultant, basically. Your advice primarily goes to the solicitor, who then passes it on to the client, or you might advise the client in conference. So it's not so much that you are making the final decision, but often when you're being asked about things like, how is this likely to go in court if we run this argument? What is a judge likely to do? What is a better way of putting this case? Your advice is likely to be heeded because that's your particular area of specialism. So it's not so much that you're necessarily making the final decision, but you are giving the advice to the solicitor and ultimately to the client, who would then decide if they want to go with it or not.
Yeah, I think I'd agree with that. I think that what I found quite, I would say, surprising, I mean, in terms of what you've said there, is that at the very beginning, I think I had a case where there was a sort of in-house legal team, because it was a very big commercial client that have their own in-house legal team. So there were maybe 2 lawyers there, and then they had instructed solicitors, so there were 2 further solicitors there, one of whom was a partner, and they then instructed me. But you are on these calls with, and I was 23, okay? You're on a call with these 5 people, and they say, fine, they're saying, what do we do next? Like, how are we going to plead this claim? And then what are the chances? And you're not necessarily making the decisions, but you are developing the strategy of how you're going to fight this case. And you make a decision at this point, that decision is followed, and then there's the next decision, and they ask you what next? And each decision then leads to another further call and strategic call that you have to make in the case. And I think, particularly if you were involved from the very beginning. And that felt like leading that team in that context.
Yeah. Just can I just add one other point on that, which is that when you're involved in a case where there's a team involved, even if it's just you and the solicitor, or it might be you and a leading barrister and lots of people at the solicitor's firm, the precise team dynamics will vary from case to case, and so your specific role you'll figure it out within the team that gets built. So it might be that the solicitor defers a lot of stuff to you, and they just want to deal with the pure mechanics of running the case. And any strategic decision or any call about, how should we write this pleading, or what cases, what parts of the case should we emphasise, the solicitor will defer to you on everything. And sometimes you get a solicitor who's been practising law ever since before you were born, and you're a very junior barrister and they want you to tell them the answer. Well, it can be a bit scary, but ultimately that's what they're paying you for. And so you analyse it and you give your best answer. Or you may have a role that is more limited to, they'll put particular things to you that they want you to advise on. Maybe there's a particular intricacy of procedure where they haven't really got the time to work through all the implications, or they haven't seen it in practice, and they want you to tell them what particular approach they ought to take on an issue for disclosure, for example. And so it'll be a narrow point. So it really varies case to case. But yeah, as Joseph said, you're always part of this ongoing strategic process. Sorry, Ben.
No.
I think there's 2 questions, so I'll have you first now.
What are the challenges being faced by the question bar at the moment? Anything particular?
What are the challenges being faced by the commercial bar?
I think draft was inclusion and diversity. what other challenges are there that we should be left without?
I think the commercial bar is very often dealing with, by its nature, business disputes and the way it has to understand the way businesses operate. And businesses, because of the nature of the competitiveness of commerce, have to keep up with the times. And so you have to have an awareness of the way in which developing technology is used by businesses. And so one of the big hot topics at the moment, of course, is AI. How does that impact on, firstly, how do your clients do their business? What impacts can it have on particular cases that might come up for you? Just to take one example, there's an issue of deep fakes that are a developing area of real concern that can be used to perpetrate frauds, for example. And so you need to have an understanding of that being a kind of thing that can come up. But you also need to be aware of how these things can impact on your own business as a practitioner in order to be competitive. So, for example, there are legal research platforms that will offer sort of AI add-on packages. So when you're doing research, you can have the assistance of an AI function. And if you're using that, that can perhaps help you be a bit more efficient, but you need to really understand how it can help you, but also you need to be really aware of how it can badly let you down. I'm sure people will have heard of cases where lawyers have ended up with egg on their faces because they've relied on a case that ChatGPT told them was a real case, and it turned out it was completely made up.
I think I would sort of add to that perhaps in a more commercial sense, you are reliant on businesses. Certainly in my field, I'm only qualified as an English lawyer. They need to basically pick English law to govern their dispute in order for me to end up with that case at the end of the day. And we're in a world where the United Kingdom is one country, and it's not the US where everything centres around this country. So, I mean, that is the theoretical challenge. The brilliant thing about English law is that because it's the most sophisticated, in my view anyway, body of law that there is, and because it's quite often a neutral law to choose, let's say, between a party based in the US and a party based in the Far East, parties do choose English law. So I think that's a challenge, but I think that it's one that, so far at least, the profession has met and done very well out of being this neutral, brilliant system of law.
Yeah, I just want to come back to the team concept that occurs. I guess ultimately you're a hired gun, so to an extent you do what you're asked to do. And picking up a bit from what you were saying, Alex, a little bit of it sounds to me like it depends on the bench strength of the other members of the team, coupled with what role they want to prescribe to you. And are you guys both relatively junior or not? Yeah. So, but there would, I'm wondering about the scenario where you might have there's two questions. One is a scenario where you may disagree with the strategy of the solicitor motor suit and how you manage that.
It happens.
So how do you manage it? How do you deal with that?
Well, I guess the first point is at what point in the case has it happened, and are you in a position to do anything about it? Because if you're given a brief for a trial that's in a month, you can't really say at that point, I don't like the way this case has been started.
Because of the disclosures, or because of why
because at that point you can't really rip it up and start again. You might have a limited ability to say, oh, actually, there's maybe a late amendment we could make. But if you think the case has been run, if you think, had I been on this case from the beginning, I would have set it up in a different way. You obviously can't go back and change that. The case has got to this point. And because you've gone through the whole case management process with it being set out as it is, if you start trying to introduce whole new grounds of the case, it might mean you'd have to redo disclosure. It might mean you have to get experts' input on whole new things. You might need other witnesses to give evidence. So the scope at which, the scope for reopening things like that and redefining what the case is about are pretty small at a very late stage. So you're kind of stuck with the way it's been done.
Because of the legal system or because of the financial cost of doing so?
I mean, basically the procedural setup that we have, which is that a judge is not very likely at a late stage to let you say, people have been preparing this case for a year and a half and spent enormous amounts of money on it. I'd like to start again. But if you're involved in an earlier stage, you may well have a disagreement with your solicitor about strategic calls, and you basically try and find an agreement with them. You try and bring them around to your way of thinking. But ultimately, you do have to pull as a team at the end of the day. So you've got to try and find a unified approach.
And it links a little bit to what you were saying, Benjamin, at the beginning when you started, and you're talking about you might get asked questions of at a tactical level. So I was trying to understand at what point one has strategic overview, like if the solicitor has sort of done a map, if you like, but how that might play out in a trial situation might be quite different. I don't know if this is correct or not, I'm imagining. I suppose it links to the last question in a sense, because if you disagree with their strategy, you must have a strategy.
Do you mean what's your role in designing how you run a case at trial compared to the solicitor having input on that?
I suppose what I'm trying to think is if I imagine being in your shoes and a solicitor presents me with a roadmap, if you like, of what the case is, or an algorithm, or whatever you want to call it. I would imagine if one's very, very, very experienced, you might look at that and think, oh no, that's not going to work, or no, this is how I'd take this, and it may map across or it may not map across, which is my last question, I suppose. But what I was trying to understand is at what point would you have a detailed enough and crystallised view of it to...
I mean...
That's a generic question, sorry.
I think, it's interesting. I think certainly my experience of this is that there is quite a lot of deference to your experience. And, we were discussing before, we're the same level of court, so we've been doing this job for 5 years each. And even though I've not been doing it for 15 years, for example, certainly in my field at least, we're very specialised. We do international trade disputes. And a solicitor may do a wide range of disputes. And even then, even if they are specialised in the same area, they also do lots of other things that you don't do. You do one thing, which is sort of research and find ways to solve or to argue these problems and advise on these problems in a very narrow sense. So you quite quickly accumulate enough experience to know how you want to argue something, how you think something should be argued. And my experience has been that solicitors are quite deferential to your experience in that respect and your recommendation. And it's quite rare that you actually sort of really disagree significantly enough that they are willing to take a completely different course against your advice and take that on their own head as, okay, we're going to do this, and the barrister told me not to do it, but I'm going to do it anyway, and then be sued for. I mean, it's quite rare. So I think that you have quite a lot of control and strategic control over the cases which you're involved in.
I suppose my question was really more, the second question was just at what point would you have a conviction about the alignment or otherwise of a case?
I don't really follow, I'm afraid. Sorry. I don't really follow the question, I'm afraid. Sorry.
Don't worry, that's fine.
We can have a chat afterwards if you want. Yeah.
For about 9 minutes left. Give them an opportunity to ask.
Yeah, just to your point about just all that's been addressed. Given the level of responsibility that you have as a commercial barrister in essentially taking the tactical strategic lead, how did you sort of grow into that role in the early years of your practice? Was it a shock to realize that, oh wow, actually these solicitors are looking to me, many of whom, as you mentioned, might have more experience than yourself? How did you gain confidence in your own decision making? What was that like for you in your early years?
It's a really good question. I think probably you do start off unsure and you second guess yourself and you worry that, why is this person who's way more senior than me asking me this stuff? And I think if you have to trust that your skill set and what you've trained for is to an extent different from theirs, as Ben was saying. You have to look at the problem on its own merits, and it may well be a tricky one, but if you work your way through, you normally will see that there's what seems to you a fairly logical way to approach the problem. Having colleagues in chambers who are supportive is really helpful, because they're not there to do your work for you. You're an independent professional. You have to make your own judgment calls. But you can always go and find somebody and say, look, I've got this problem. I think the answer is this because X, Y, Z. Does that make sense? And very often they'll go, yeah, that makes total sense to me. It sounds very sensible. Occasionally they might say, oh, have you thought about this? But just having that sounding board of other people, because it's a bit of a cross-check, but also it's just for that reassurance that you do actually know what you're doing. But mainly it's just working through the problem and applying your skills to it. You usually will be able to come to a sensible answer.
Yeah, I completely agree with everything you said there. I think that the specialisation helps with that, because, let's say in pupillage, if your chamber is sufficiently specialised, then you will have seen perhaps that problem or similar problems before already, even by the time that you're in your first year, and that really helps you have the confidence at the beginning. I mean, certainly at my chambers, you have a mentor for the first year that you can ask that kind of question to, and a formal support structure, but also a completely informal one where you can go into anyone's room in chambers and ask for that help. And both of those things really, really help with it. But it's also difficult. It's a difficult job. I found the first year or 18 months stressful for that reason, because you are taking really difficult decisions. I mean, quite often in my field, it has been to an in-house lawyer who has found they don't know the answer. It's been to a solicitor who doesn't know the answer. And you are only seeing a narrow section of disputes where other people who are also intelligent do not know the answer to it. And so they're all difficult problems. And they could quite often, all of them, go either way. There's someone on the other side arguing that you're wrong. And so they are difficult. But the support structure and your experience helps you find a way through that. And then after a couple of years, you get much more confident at dealing with those kinds of problems.
Yeah. But not 100%. Yeah. This week, I went into a colleague's room, who's a good friend of mine, with a contract, said, I'm trying to understand how this works with that, and I think I'm a complete idiot. But I don't think this matches with that. And she looked at it and went, no, you're right, it doesn't work at all. And so just having that reassurance from somebody else that you're not completely mad. And the same, I've got there's people junior to me who phone me up all the time as a sounding board about things. I phone up senior people all the time, and you can just wander into people's rooms and ask them stuff. It's really, really helpful to have that there.
Thank you.
Hello.
In terms of what I can bring to the commercial bar, so I can be noticed in the pupillage application process, some keywords and what are some of your challenges that you face in your daily work, and how do you go around dealing with this, and how I can highlight some of the things that I've told in public procurement, for example, or financial, private equity sector, that I think it's quite a good experience for bringing on to the commercial market. How do you notice in these things? If that makes sense?
Yeah.
I mean, I think I've got your question, and I would explain it like this. I think that, I'm on the pupillage committee at Quadrant, for example. So I see a lot of applications, and what we look for in applications, I would say, are broadly three things, which have been mentioned by both of us as reasons why we're interested in the bar. Those things are basically intellect, advocacy, that you enjoy advocacy, and that you're good at advocacy. And that sort of third point of maybe that you enjoy a bit of the independence of the bar, or taking a leading role in teams, or making strategic decisions and things like that. So I mean, I can't speak to your particular experience or what you've done and all of that, but if your experience demonstrates that you are going to be good at those things, then put that in your application, put that in your answers, feed it into what you're saying as evidence of why you're going to be good at X, Y, and Z, which are the things that we're looking for. So I think if you can evidence your application in that way with your own experience, I think that it will help. Does that help?
Yes.
Okay.
Yeah.
Okay, last two questions. I'll go with you first and then you.
As aspiring commercial barristers, what's one advice that you wish someone told you when you were in this instance as you were right now? That's a loaded question.
Show, don't tell in your application. You would not believe the number of applications I read, I'm sure Ben is the same, that are long and verbose and full of adverbs that don't really say anything at all, other than I really, 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 really want to be a barrister. It's not very helpful or insightful in telling us why we should take you on. Use really clear evidence to explain the points that you're making in favour of why you want to be a barrister, you want to do the sort of work that the chambers you're applying to does, and why you're going to be good at it. And that can be a law-related example, it could be a non-law related example, but think of it as a piece of written advocacy. You're going to do a job of being a barrister, you're going to be writing advocacy documents, which will be in order to persuade a court that your case is right and the other side's case is wrong. The way you do that is not by long literary passages, it is by justifying it rigorously with reference to evidence. So treat your application in the same way.
I was going to say almost exactly the same thing. I'd say that's how important what he has just said is for your application. So I would completely endorse that. The only thing that I would also say is, when you're doing that, structure it. And I think that barristers, there's all this classic like everything is 3 points. I mean, these are cliches because they have some weight. If you can structure your arguments like a barrister would structure their arguments, then you're showing that you're ready to do the job in your application. So I think that that's not necessarily the advice I would give to myself, but that's the advice that I would give to the people whose applications that I read.
And final question.
Yes, how do you deal with cases where the law is not clear-cut? Now, let me give you an example. I'm dealing with a case in the High Court. It's a personal case. There is an order which was sent by a judge by email to me. I'm not seeking legal advice. So I didn't receive the order. A few months later, I got a correspondence from the other side saying that you need to pay us out of cost. I said, well, I never saw this order. It's the way it was emailed to me. So there was nothing in my inbox. I went through my junk email, and there it was. The order was there. I never saw it. So the law is not clear on that, for instance. How do you deal with cases where the law is not clear? Thank you.
If what you mean is you have a case where the applicable procedure to your situation is not totally clear as to what the answer is in your case and what you ought to do, that does come up sometimes. And you've basically got to, if you can find a way to clarify it, that is your job. You would look at the relevant rules, you would look at any cases interpreting those rules, you'd look at any practice notes that might indicate how the court normally approaches it, and you find as best you can how to clarify it. But ultimately, you might end up with a situation where you cannot find a clear precedent for what the answer is, in which case you have to advise your client, well, here is my best guess, but it's not that I can't find any authority on it as to what the court is likely to do in this situation. But you have to make clear to them there is that element of uncertainty, and that's where your advice becomes really practical, which is, well, what are they? If I'm wrong, what are the practical implications going to be? Can we cover off both sides? So it might be a really simple thing like interpreting a bit of the civil procedure rules. What is the deadline for doing XYZ act? It might be the first, it might be the second. The the obvious answer to that is whatever it is to do it on the first, and then you won't have a problem. So it's about, if you've got that ambiguity, how can you shortcut to practically making it not a problem anymore?
And there's a lot of that if you're advising at an early stage in terms of there's a lack of clarity here. What is the safest option going to be for the client that covers off as many of these possible options as possible? And then, but there's also, a later stage where the law is unclear. The hearing is tomorrow, and it could go either way, sort of thing. So firstly, you advise your client that it's uncertain, it's difficult to predict, it could go either way. And then the other part of the job of being a barrister is arguing your case and just fighting your client's corner as strongly and as persuasively as you can. And there comes a point at which that's what you just have to do, regardless of how unclear it might be.
But I think that throws up a really important point about the very nature of our job. We are not academics. There is an element to which we have to slightly kind of pontificate about difficult problems, and that's a big part of our job and what makes it interesting. But ultimately, you are there to serve the interests of your client. And if there is a practical and straightforward way you can get the clients where they need to be without having to go through a quagmire of a point of law that is really uncertain, you should obviously get them to where they need to be more straightforwardly, because you're there as a service provider for their interests. It's just that along the way we get to deal with some really interesting problems.
Is it possible, I know it's the last question, if you're having some cases which are happen, for example, in Australia or another country, can you use that in this particular situation to persuade the judge to be on your side? If you're having some precedents...
In a different country, yeah.
For example, for this junk mail issue, there are some precedents in Australia, nothing in England.
Yeah. I don't think we're going to get into the specifics of whatever your case is. However, I think it's right that foreign jurisdictional cases, particularly if they're from legal systems that have a resemblance to English law, they can be of persuasive effect, even if not directly binding.
Yeah, I've certainly cited cases from Singapore and things like that address a problem that has not been addressed in English case law. So it doesn't always work.
No.
Unfortunately, we are out of time, but can you please allow the report to